So far we've talked about what torts are, why negligence is the core framework, and how intentional torts work when someone means to do the act. Today we're moving on to the third major category of tort law, strict liability. This one feels strange at first because strict liability is about responsibility without fault. No intent, like intentional torts, and no carelessness, like negligence. It's just liability. So, what is strict liability? Strict liability asks a very different question than negligence. Negligence asks, did you act unreasonably? Strict liability asks, should you be responsible anyway? Under strict liability, it does not matter how careful the defendant was. If certain conditions are met, liability attaches automatically. This is policy choice by the law, okay? So why strict liability exists? Because some activities are so dangerous or so risky to the public that the person engaging in them should bear the cost no matter what. The idea is simple. If you choose to benefit from a dangerous activity, you also accept the risk. Strict liability shifts the loss away from the innocent victims and onto the person that creates the danger. The big three strict liability areas. Okay, so strict liability shows up most often in three places. Think of these as the only buckets you need to recognize at first. So 1, animals. 2, abnormally dangerous activities, and 3, defective products. If a fact pattern fits into one of these three things, your strict liability radar should immediately turn on. Strict liability for animals. Animals are treated differently depending on what kind of animal we're dealing with. Wild animals are almost always strict liability. If you keep a wild animal and it hurts someone, that's on you. Domestic animals are a little bit different. For domestic animals, strict liability usually requires knowledge of dangerous propensities. Once you know the animal is dangerous, you're responsible for the harm it causes. This is less about blame and more about control. Okay, so the second topic, abnormally dangerous activities. This is the classic law school category. An activity is considered abnormally dangerous when it carries a high risk of serious harm, even when the reasonable care is used and it is not a common activity in the community. So think explosives, blasting, toxic chemicals. If someone gets hurt because of the dangerous nature of the activity itself, strict liability may apply. The key phrase here is harm must result from the risk that makes the activity dangerous. Okay, so products liability. Products liability is the most tested form of strict liability. If a defective product injures someone, liability may attach even if the manufacturer was careful, even if the seller didn't know about the effect, and even if no one intended harm. The focus is on the product, not the conduct. Products can be defective in different ways. You can have a manufacturing defect, a design defect, and a warning defect. So we will slow this way down in later videos. For now, the takeaway is pretty simple. If a defective product causes injury, strict liability is always on the table. Okay, so when it comes to strict liability, all three subtopics, causation still matters. This is an important misconception. Strict liability does not mean automatic liability for everything. You still need actual and proximate cause. The harm must be connected to the dangerous characteristic. If the injury has nothing to do with the risk that justifies strict liability, the claim fails. This is where a lot of students lose easy points, okay? So, defenses in strict liability. Defenses are more limited here, but they do still exist. A common defense in strict liability includes assumption of the risk and sometimes comparative fault. Ordinary care by the defendant is not a defense, and that's the whole point of strict liability. So, how do you spot strict liability on exams? This is the mindset. When you see facts involving dangerous things, dangerous animals, dangerous activities, dangerous products, danger, pause and ask yourself, is this a situation where the law might impose liability regardless of care? If yes, strict liability analysis belongs in your answer. How strict liability fits with negligence. One last thing. Strict liability does not replace negligence, and often when you're analyzing strict liability, you must analyze both. If strict liability fails, negligence may still succeed. Think of strict liability as a shortcut, not a substitute for negligence, okay? All right, so in closing, today the goal was awareness. You do not need to master every test yet. You just need to recognize when strict liability is in play and understand why it exists. Next, we'll start slowing things down again and getting more granular, just like we did with negligence. When you're ready, the next logical step is negligence deep dive, starting with duty, or products liability as its own episode. Okay? So, thank you for watching. And if you like the information, please leave a comment, like, share, subscribe to my YouTube. I'm going to keep breaking down these topics. And as I said, I'm going to do a deeper dive into negligence and products liability next, because those are going to be pretty much the bulk of the analysis if torts is tested. So let me know if you have any questions. Let me know if I'm unclear on anything. And thank you again for watching. Bye-bye.